All right, so hello and welcome to the judicial process. So last class we looked and we kind of finished up basically pre-charge proceedings, pre-arrest proceedings. Right, so we looked at everything from search warrants, arrest warrants, to grand jury indictments, to informations, to complaints, really kind of starting off the criminal justice process. What we're going to move into today are pre-trial proceedings. So everything that happens before the actual, what we think of as a trial, occurs. So let's jump in. Okay. So if you recall, courts play a very minimal role prior to an official charge. Right, so if it's a grand jury, they'll issue subpoenas on behalf of the grand jury. They can enforce them. There's a little bit of judicial oversight. But really, courts take a step back when it comes to pre-arrest proceedings, especially if we're just kind of in the investigative stage. That being said, as soon as an arrest is made, so if we have an indictment or we have a complaint or an officer sees somebody committing a crime, once an arrest is made, the court system shifts from this kind of passive observer that doesn't really have their hands in the pot into a very active participant and probably one of the most important participants in the criminal justice process. Now, you may be thinking, like, especially when you see on TV, that pretrial proceedings aren't really, for lack of a better word, sexy. Right? We all have seen on TV like the criminal trials and Law and Order, and those are, one, just unrealistic. If you ever watch a trial, it is boring beyond belief, depending on the subject matter of the trial. But it's long, it's a drawn-out process, etc. That being said, pretrial proceedings are actually probably, arguably, the most important part of the American criminal justice system. Right? So we're at the most important part in today's discussion. And if we think about it this way, so only about 10% of cases will ever go to trial. Right? So we're talking really, the estimates go from 10 to 1% of felonies, and then virtually no misdemeanors go to trial. We usually engage in plea bargaining and the process early. That being said, even though very few cases ever actually make it to a full-blown trial, every single case, when an arrest is made, every single case, you will go through pretrial proceedings. And so even if you decide to plea bargain, part of the plea bargaining process gets involved in pretrial proceedings. So this will touch everyone who gets arrested. So what the first thing that's going to happen is once you are formally charged, once you're arrested, again, depending on if we have a complaint or an indictment, we'll talk about what happens there. Generally speaking, you're going to have what's called the initial appearance. It's sometimes referred to as the first appearance or the Gerstein hearing. So it really is the first formal step in the adjudication process. Right? And this is going to occur usually when we have somebody who has made complaints or we have information. Indictments, you'll still have initial appearance, but it'll be wrapped up in the arraignment, so they'll happen at the same time, and we'll discuss what that looks like in a moment. But right now, we're just thinking we don't have a grand jury indictment. Instead, this is a prosecutor filing an information or a complaint because of what police saw, what police did, what committed police made an arrest. So we bring you into court, right? Because this is our first check on the executive branch. All right, so police are a member of the executive branch of government. Courts, obviously, are a member of the judicial branch of government. And so the initial appearance really kind of serves as that first check, that first step. Now, during the initial appearance, we really kind of do four things, right? So the first thing we're going to do is we're going to make an initial determination, right? So this is very provincial, it's very, very loose. But we do an initial determination to make sure that there's sufficient probable cause that one, a crime was committed, and that two, the person who is standing before you arrested committed the crime. Right, again, this isn't the formal determination, this is relatively informal. Usually what will happen here is the prosecutor will get up and read the police report to the court. And really the defense doesn't get a chance to rebut it. As long as the court determines from the police report that there's probable cause, then it's fine. Right? We don't have a formal determination yet. This is relatively informal, but at least it's a first check. Right? At least we're making sure that they're just not making arbitrary arrests. There's some kind of reason behind it. So 99.99% of the time, at the initial appearance, we're going to find that there's probable cause to bind the person over, either for an indictment or preliminary hearing, and we'll talk about those in a minute. At this point, and again, this also occurs in a preliminary hearing, we advise the defendant of his or her rights. Right? So once the judge finds that there's sufficient evidence that there's probable cause, then the judge will tell the accused, right now at this point the defendant, what their rights are. And so what they're going to do is they are going to repeat Miranda. So just like the police do the Miranda rights, court is going to do the Miranda rights. Right? And they're going to say, just so you know, you've right to remain silent, continue to say, can we make sure the law, direct an attorney, yada, yada, yada. Right? They're also going to discuss with the person, depending upon their education level, depending upon the circumstances, what other maybe judicial rights that they have in terms of if you get a complaint, but we're in a grand jury jurisdiction, right, you have the right to have your case heard by the grand jury and an indictment issued, or you can waive that right, and we're going to inform them of that. Now, that's a lot to take in. I mean, that's a lot, right? You're arrested, you're terrified, you're stressed out of your friggin' mind, and the court's like listing off like legal rights and things that maybe you don't understand. So, at this point, we also generally appoint counsel. Right? So, if somebody qualifies for a public defender, and to qualify, if you recall from our discussion about defense attorneys, there's all kinds of different equations. Each state has their own requirements for a public defender. But if you qualify for a public defender, the court will appoint counsel at this point. Now, usually you have the public defenders are in the courtroom. Massachusetts, the public defender represents you during the initial appearance, no matter what. I mean, you can have a private attorney come in if you want, but even if you're rich, they'll represent you during the initial appearance, and then they'll make you get your own counsel. If you're indigent, they stick with you. So they're already in the courtroom. We already kind of know what's going to happen. We know in advance before the preliminary hearing begins, or the initial appearance begins, if you qualify for public counsel. So if you do, we're going to appoint an attorney. The attorney is going to basically have a couple of minutes with you, usually before you go into the initial appearance. See, when I did it, my average was roughly 2 minutes. I got to go down to the holding cell to talk to my client before we went up to the initial appearance. Now, to be fair, there's not much that happens from the defense aspect of the initial appearance, with the exception of bail. Right, so this is where we make bail arguments. Now, we'll talk about the purpose and the structure of bail in a second, but I mean, generally speaking, bail cannot, under the 8th Amendment, be used to be punitive. Right, so we can't punish somebody by giving them excess bail. We also, under the 8th Amendment, at least interpretations of the 8th Amendment, there is no right to bail. There is no constitutional right to bail. All the Constitution says is, if we decide to give somebody bail, it cannot basically be even more than 1 cent over what is necessary to have them returned for trial. Right, and so what I would do is I'd meet the client, and I'd quickly talk about their job, their education, their family, mode of transportation, just as much information as I could get to show that they would return for trial. And what would happen is the prosecutor, after they read the police report, they would make a request for a certain amount of bail, and then the judge turns to the public defender, turns to me and says, what's your argument, counsel? And you had to be realistic in your arguments. I remember that there was this one case where, I don't know if I told you the safe case. The guy got through somehow Boston Logan, where the 9/11 hijackers flew out of, with a locked safe full of cash that he stole. And he was on his way, he was from South America, he was back on his way to South America. They find out that it's him when he's kind of midair. The plane lands in Georgia for refueling before it takes off to South America. And they put a customs hold on him, an immigration hold, until police can get there and arrest him and bring him back to Massachusetts. I had to, in good faith, argue to the court that he was not a flight risk, that he would return for trial. He was literally on a plane for South America. That was fun, because as soon as I said, Your Honor, he has very strong ties to the community, and the best I can tell does not present a flight risk. And before I could say flight risk, the judge just like $100,000 and just cut me off. Like, it was just like, we all kind of knew, like, I have to make this argument, the judge knows I have to make this argument, but he doesn't want to hear it because it's obvious this person's a flight risk, so he just kind of passed it over. We'll talk a little bit more about bail in a second. Now, that being said, with the initial appearance, you must take the defendant, if you make an arrest, this is kind of our general quote, without unnecessary delay before a magistrate or before a state or local judicial officer. All right, so basically, whenever you make an arrest, you have to take somebody before the court as soon as possible. Or they have to see a judge as soon as possible. And the idea here is we don't want somebody waiting in court or jail for their initial appearance, for bail to be set. We don't want them waiting 3 months for them to get bail. Right? Like, it's just not what we want to do. So you have to go without unnecessary delay. That's why people are in large cities. A lot of large cities have night court, right? So New York City has night court, which literally is court at night, right? And you get busted at night, they're going to haul you in front of the judge at night, right? That night, their court system is 24/7. Because it's such a large city, because of the need, et cetera, et cetera. But if you're in a jurisdiction that only is Monday through Friday, regular business hours, and let's say the worst time to get arrested is on a Friday, because we get a rule from Riverside v. McLaughlin, and this is in box 3.2, in which the Supreme Court sets a strict 48-hour requirement between the exact time the defendant is arrested and their initial appearance in court. All right, so you have a 48-hour window. Well, if you get arrested on a Friday, you'll go before a judge on Monday. They're going to keep you in jail until then, unless they release you on a summons or something along those lines. But if they don't, you're waiting all weekend. If it's a holiday weekend, you might have to wait 3 days. Right, so there is some flexibility in Riverside versus McLaughlin, but it's still fairly strict, 48 hours, right? From the moment that we make the arrest, you have to be brought before a judge. Now, this is why you see some police departments do say they can hold the defendant or a suspect for 48 hours, right? You hear that on TV all the time. This is why. So theoretically, you could arrest somebody without having probable cause, knowing you don't have probable cause, and release them before the 48 hours is up, and they don't have to go before a judge. Now, they can always sue, right, for abuse of power. They can sue for deprivation of civil liberties. They can sue for a lot of things. Those lawsuits never really work, and most people don't. So 48 hours between the arrest and the initial appearance, fairly a strict timeline. So we talked about this a little bit about bail. So this is one of the most significant predictors of how a case is going to turn out. So, right, when we're talking bail, that means that we've said that there's at least 50.01% or 50% in the feather or 51%, however you want to think about it, chance that a crime was committed and this person committed the crime. Okay. You are, at this point in time, presumed innocent. Now, we say that. We say you're presumed innocent. Are you? In reality, no. We say it, but it's a little tongue-in-cheek. Because most people who get in are going to be found guilty, right? And whether it's through plea bargaining and the problems in that process with the trial, most people are guilty. They go through the justice system. That's why they probable cause. Like, it's more likely than not that they're guilty. Bail becomes really important because it tells us a few things. First, it tells us how strong the prosecutor's case is, right? So when they read the police report's really detailed, there's all of witnesses, the defense attorney's taking notes going crack, 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 crack. And bail is hugely important in determining somebody's ultimate sentence or the terms of their plea bargaining. So if we do not give somebody bail, if we hold somebody in pretrial detention, right, we do not give them bail, their sentence is likely going to be much, much, much more severe than somebody in a similar position who got out on bail. Right? Again, there's severity of the crimes coming into play. There's a lot of factors that come into play, but it's one of the biggest factors, especially plea bargaining. Right? The prosecutor can give you less favorable terms in plea bargaining, knowing that you'll take them. Right? So if you're out free and you got like 2 years before your trial date, you're living your life, and the prosecutor offers you a plea deal, it's probably going to be a decent plea deal, right? Just to kind of get it off their plate, get it out of the system, whatever it is. But if you're in jail, that prosecutor doesn't have to be nearly as giving, because you're going to want to get out of jail as soon as possible. Right? So you're going to take whatever deal that comes your way. Once you get out of jail, this may mean you want to go to ideally everybody wants to get out of jail and then go home. But a lot of times you may just want to go to a prison. And it sounds weird, but county jails, depending on the county and their resources, they are stocked. The people that are in there are people who are presumed innocent, but we put them in jail, waiting trial, people who pled guilty awaiting sentencing, people who've been sentenced waiting for a bed to open up. A lot of times there's not necessarily security segregation, the classifications. So you may be somebody who is in jail for pickpocketing and your roommate is a triple murderer. Also, jails don't have the programs and the resources that prisons do. Right? So you're lucky if the jail has a library or has magazines. Jails are very boring places. There's nothing to do. Prisons, you will be expected to work. Prisons, you'll be given vocational opportunities. So under the federal system, in order to be released, you have to have a GED, have earned your GED in prison at least. Boston University offers free classes to inmates. Right, so you can get your bachelor's degree for free from BU. We're kind of working on something here along those lines as well. But there's all kinds of things that you can do. They have libraries, especially in the federal system. Federal system, they have all kinds of stuff. I remember when I took a tour of FedMed in Springfield, Missouri, so it's the male prison hospital, federal prison hospital. They had a music room. They had like recording studio type setup to it. They had arts and crafts rooms. They had gyms with like treadmills and all kinds of stuff. It still sucks because you're still in prison. It's still, not a great thing. It's still dangerous. They usually have less resources at state prisons, but they have stuff to do. Right? So if nothing else, you can work on your case. You can write appeals to courts. You're bored, you're just writing. That's something that you can't necessarily do in jail. Right? So if you're just sitting in a cell doing literally nothing for 2 years, and you know like you've got another year ahead of you or something like that, and the prosecutor says, tell you what, if you plead guilty, we'll recommend a sentence of 5 years in prison. That doesn't sound so bad. Especially, but I guess the problem comes into play is if you were in that same situation, but you got bail, that prosecutor might offer you probation. Right, so that's how big the disparity is between the two. So again, bail is going to tell us a lot. Not only how much the bail is, the foundations for the bail, and what the ultimate outcome will ultimately be. Now, as I said before, the sole purpose of bail, is to ensure that a defendant will return for trial. Right? And again, a simple bail determination can affect the course of somebody's entire life. If they don't get bail, then we have higher sentences, yada, yada, yada. But again, the sole purpose of bail, the sole purpose is to make sure that you return for trial. Contrary to popular belief, it's not to protect society, right? Even though we do take that into account, but remember, we're presuming you innocent, theoretically. If we actually presumed you innocent, we wouldn't even have a bail question. We would just do what we do. In fact, Illinois actually just eliminated cash bail, the whole cash bail system. Like you either get held in detention or you get set free. Like that's it. That being said, most jurisdictions, and this does not include federal courts, but if we do look at the Bail Reform Act of 1964, there are some differences there. As a matter of state statute, most states give you a right to bail. Right, so there's no federal constitutional right to bail, but many states give you, under their constitution, the state constitution, a right to bail. Specifically in non-capital cases. All right, so capital case can be anything where we can impose the death penalty or life without parole. And those are the two sentences that make it a capital case. In those cases, this absolute right to bail does not apply. Now, don't take this on face value as something that's easy, right? Let's say that you've been arrested for robbing a liquor store. Okay. You have, let's say in your particular state that you're in, you have a right to bail. Well, if the judge sets bail at $100,000, you going anywhere? Nope. And there are bail bondsmen. Some states don't allow them. So Massachusetts doesn't have bail bondsmen. even then you still have to put up $10,000 for them to a minimum, for them to put up the rest of the money. And if you're robbing a liquor store, you probably don't have that kind of cash, right? So even if you have an absolute right to bail, we can set it really high under the guise that we are making sure that it's not more than necessary, knowing that you're not going to get out, right? So it's like, you have the chance to get out, but you know, you can afford it, sorry, not our problem. Now, that being said, when we talked about the hierarchy of the courts, we discussed that the Supreme Court of the United States hears cases for the most part as a matter of discretion. So they decide what cases they will hear, what they will not hear. There's a great exception to this rule. And most criminals don't know about it, and most attorneys don't want to screw with it, but if you're in prison and you can't get out, why not? So you can appeal your bail all the way to the Supreme Court of the United States, and the Supreme Court must hear your bail arguments. The thought process behind this is, again, you are presumed innocent. And if we are charging even one cent more, if we are saying, if it only take $5,000 to get you back to court, and we say $5,000 and 1 cent, we're in violation of the 8th Amendment. So you can, basically what happens is you're going to have your initial appearance before a court of limited jurisdiction. You can appeal to the court of general jurisdiction. Then you can appeal back to the state court of appeals. Then you can appeal that to the state Supreme Court. And then you can appeal that all the way up to the U.S. Supreme Court. Now, if you appeal your bail to the U.S. Supreme Court, the whole court will not hear it. Right? So justices, as when we looked at judges, justices sit over a particular number of districts. Right? So whatever district you're in, you can appeal up to that Supreme Court justice. That Supreme Court justice is going to have a telephone conference. They're not going to fly you to D.C. or anything like that. And they'll make bail arguments and go from there. Now, this can get tricky because unless you have a really good argument, you're going to piss off that justice. And the thing about bail is it gets reviewed de novo, which means it gets set anew. So each one of those stages, the court can up your bail, can down your bail, or maintain your bail. But you better believe if you get to the U.S. Supreme Court and you don't have a good argument at all, you're just playing the system, your bail is going to go up. I mean, it's just have almost, it's not supposed to be punitive, but it might. That being said, if you're stuck in prison, there's absolutely no reason, and like, you can't afford bail. I would say it's like $200,000. You can't afford bail. There's absolutely no reason not to go all the way to the Supreme Court. Like, why not? Nothing else to do. If you're in jail, like county jail, you have nothing else to do. So again, this is one of the things that is reviewed by the Supreme Court of the United States. Very, very important. Now, defendants who are not given bail, right? So we don't have to give bail, specifically if it's like a capital case. Under the federal system, there are certain rebuttable presumptions that we won't give you bail. So if it's like a sex crime, if it's a drug trafficking crime, but something along those lines, generally speaking, we don't have to give you bail, but you can always rebut that presumption and make an argument for it. So if you're not given bail and you cannot afford bail, and this includes something called a surety. A surety is just a bail bondsman, right? So for those of you who don't know how bail bonds work, basically, if you're in a state that really isn't a bail bonds, usually around the jail, they have a bunch of offices, and they have bail bondsmen. And what these guys do, and gals, what they do is you go to them and you say, you have your family go to them, obviously. Say, you know, my brother's bail was set at $100,000. We can't afford $100,000. So the bail bond person is going to say, okay, you give me 10% of the bail, non-refundable, so I keep it. I'll keep tabs on you, but I'll tell the court that if you don't appear, I'll pay the $100,000. That's why we have bounty hunters, right? Because you put up, let's say $2,500, the $2,000 or $25,000 cash bond, and you put up $2,500. The bail bonds person, that's their money now. But if you don't show up for trial, you do not show up to court when you're supposed to, that court can order that surety to pay the full $25,000. But they have to write a check for $25,000. Now, usually if it's a surety, the court's going to give them a couple of weeks to track you down and bring you in. That's again where bounty hunters come into play. Right? So they basically are looking for people who ripped off the bail bonds person. They're tracking them down. Bail bonds, bounty hunters, they can put you in detention, so they can handcuff you. They can use reasonable force. There's a lot of requirements. It goes from state to state. Some states require licensure, other states do not. But they can put you in handcuffs, throw you in the back of a car, and they have to take you to the jail. Right? And they surrender you to the jail, and that way you're in custody, and you don't have to pay $25,000 or $100,000 or whatever the actual bond was that you said you would pay. Right? So, I mean, that's kind of just how that process works. But let's say you can't afford bail and you can't afford to pay the 10% or 15% with the surety. Right? I mean, again, even think about a $25,000 bail or bond. 10%, that's $2,500. I mean, how many of us, like excluding parents or anything like that, have $2,500 there? You should be like, yeah, I can get rid of that. It's not a big deal. I can still live my life. I know I don't. Like, I'd be in jail. So if you can't afford it or you're not given it, you're held in what's called pretrial detention. At any given time, there are approximately 480,000 people in pretrial detention. Think about this. In the land of the free, where we have the most prisoners in the world, per capita and in number, where we presume you innocent. Almost 500,000 people are presumed innocent and are sitting in a jail waiting for trial. But it's not there to punish them, it's just there to make sure they return. That's a pretty high figure, especially when you consider violent crime is going down. Yes, we've seen a slight uptick over the past year and a half or so. But for the most part, we're still at the lowest crime rates that we've ever been at. So this number is really upsetting. Right? It's not a good number by any means, shape, or form. Now, there are racial disparities that we have discovered in bail determinations and pretrial detention orders. So generally speaking, pretrial detention orders or bail decisions, if you are white, you are generally going to get, I mean, again, this depends on the court, but if we look at the studies, you're going to get a better bail, one that's more affordable than, let's say, if you are Black or Hispanic. And so we've talked about how there's racial inequality and racial disparities throughout the system. Well, this is true of bail as well. Again, these are studies of people who committed the same crimes, but their demographics are just different. And we see that there is a big difference, and it's a pretty big difference in the amount that somebody, let's say you have an armed robbery, a white man, the amount that you're going to get is going to be a lot lower than if you have armed robbery and you're a Black man. That's not true all the time, but there's pretty decent literature on point. Now again, it cannot be punitive, but think about this. We have 500,000 people in pretrial detention at any given time. And they're waiting for trial, which may take 1 year, 2 years. It may take 6 months, who knows? Let's say it takes 6 months. It won't, but let's say it does. It's not supposed to be punitive, and you're presumed innocent. If your employer finds out that you're in jail and that's why you haven't shown up for 6 months, or that you can't come for 6 months to work, are you going to have a job? No. You don't have a job, are you going to be able to afford your mortgage? No. So you're going to lose your house. You may lose family, or depending on the charges. Because we're all the same. When we read but if, okay. Yes, so with the preliminary hearing, it happens if we don't have an indictment, and you as the defendant are entitled to request a preliminary hearing if there's no indictment. Now, the preliminary hearing occurs before a judge or a magistrate. We're talking at the federal level. Federal level, we're going to indict everyone for the most part, but you can waive it. But in the states, if we don't have a grand jury, you are entitled to a preliminary hearing. Now, the preliminary hearing has to occur within 14 days of the initial appearance. All right, so you have 2 weeks from the day that person was brought for the initial appearance to have the preliminary hearing. And 21 days, so you get an extra week if the person is not in custody. All right, so if they're in custody and they get pretrial detention, you have 14 days to go for a preliminary hearing. If they're not in custody, you have 21 days or 3 weeks for a preliminary hearing of the initial appearance. Now, that being said, the preliminary hearing is where we have an official determination as to probable cause. All right, so this is the formal determination that 1, a crime was committed, and 2, it's more likely than not that the defendant is the person who committed the crime. Now, its goal is the same as the grand jury, right? To make sure that we have oversight of the police and that we're treating defense fairly and protecting their rights. What's interesting about preliminary hearings is if you're a defense attorney, you would rather your client have a preliminary hearing than an indictment. Because remember, when we discussed indictments and grand juries, they're a secret process. You may not even know about the meeting to talk about you, investigate you until you're handcuffed. Well, that's a formal determination of probable cause. You're not entitled to a preliminary hearing if you're indicted. If you aren't indicted, you are entitled to a preliminary hearing. And during the preliminary hearing, the prosecution has to present evidence. So it's almost like a mini trial. They have to present witnesses, they have to present evidence, etc., to prove to the judge that there's probable cause. Now, here you are allowed defense counsel, and the defense counsel cross-examine prosecution witnesses. Right, so the prosecution will go through their questioning, and the defense counsel can come in and question the prosecution witnesses. There is a problem in the sense that at the preliminary hearing, the defense or the defendant is not entitled to call any witnesses. So even if they have an alibi, and it's a great alibi, they're not entitled to call their alibi witness. All right, so it's only the prosecution, but you can cross-examine prosecution witnesses. Now, the reason defense attorneys like this is because it gives you a sneak peek at what's gonna happen, right? Of what the prosecution has, right? And it allows you to kind of test people out. So when you're cross-examining them, you can start to push their buttons. Like when this person does testify in front of the jury, are they the type that are going to connect emotionally to the jury? Are they going to cry? Are they going to yell? Are they going to come across angry? Are they going to come across bitter? And there's all kinds of things that you're going to be playing with. You're going to take a look at the evidence, but you're also going to be seeing, all right, how does this witness testify? And is it going to resonate with the jury? And that will help you make decisions later on when it comes to plea bargaining. All right, so they have great witnesses that will connect with the jury on an emotional level, and they have really good evidence. You're probably going to take a plea bargain rather than risk going to trial. Because generally what we see is plea bargaining, you usually get a better or shorter sentence than if you go to trial and you're found guilty. So this is basically everything I just said. Defendant is entitled to counsel, cross-examination of prosecution witnesses, and introduction of evidence. That being said, what's interesting about preliminary hearings and really any stage before the trial is, generally speaking, the federal rules of evidence do not apply. So that means things like hearsay, which is just a statement made outside of court, used inside of court to prove the truth of the matter asserted. It's in the 800 block of the federal rules of evidence. Or even illegally obtained evidence. All right, so think about somebody busting into, a police officer busts into a home without exigent circumstances, without a warrant. They just kick open the door and they do a search that's completely illegal. During the search, they find drugs and guns, all kinds of stuff. They seize them and they arrest the person. At the preliminary hearing, and really any stage before trial, even though that evidence is going to get suppressed, we know that evidence is not going to come in at trial. It's not going to be allowed to be heard by a jury. The judge can rely upon illegally obtained evidence to find probable cause. So even if we know it's being thrown out, even though we know it's a gross violation of civil rights, constitutional rights, we can still make our decision as to probable cause based upon the illegal evidence. All right, so again, we're not at trial, so there's no real, I mean, the rules of evidence are kind of suspended to a certain degree. Now, again, presumably the prosecutor does not have an indictment, right? So a prosecutor can seek an indictment while the preliminary hearing is going on. So the preliminary hearing may take a couple days if it's a really intense case, or it might just take an hour, 30 minutes if it's just a small case. But the prosecutor can get an indictment in that time frame. And if the prosecutor gets an indictment, that stops the preliminary hearing because the indictment is the official determination of probable cause. There's no reason to have a preliminary hearing. One has already been made. Now, if the judge finds that there is sufficient probable cause, even relying upon the illegal evidence and evidence that's not admissible in court, hearsay, the defendant, or I should say, or if the grand jury returns an indictment, the defendant will be what's called bound over for trial. And if we're talking in the next step, when we bounce somebody over for trial, is the formal arraignment. Right? And the formal arraignment, that's where we tell you what you are officially being charged with. We tell you the penalties that you're looking at. In most jurisdictions, this is where we allow you to enter a plea. The most times you're going to plead not guilty. It's just usually in your best interest, even if you are guilty, so that you have time to plea bargain and all that things like that. Now, again, the arraignment, it has two purposes, right? So the arraignment is going to feel a lot like the initial appearance, and if it's an indictment, it's going to have the initial appearance, the counsel, and everything else appointed during that time frame. But if we're not talking indictment, we're not talking grand jury, we're just talking prosecutor, it puts the defendant on formal notice of the charges and allows them to enter their plea. So contrary to popular belief, there are more than 2 pleas. Yes, you can plead guilty. I wouldn't recommend it, but you can. A lot of times if it's a misdemeanor, like just a real low level, you're going to get like a small fine. You'll just plead guilty. Like, why do you have to go back to court and go through all this headache of keep returning every few months? We need to plead guilty. So you can plead guilty. But again, I don't recommend it, especially as the charges get more and more severe. Don't plead guilty. Plead not guilty. You can always change your plea later. Unless you plead guilty, and that's a whole other story. So you can plead guilty, you can plead not guilty, or you can plead nolo contendere, which is also called the Alfred plea. Comes from a case called Alfred. Go figure. And basically what a nolo contendere plea is, or what a Alfred plea is you say to the court, I am innocent, but I recognize that you have a lot of evidence. You have sufficient evidence that if we went to trial, I would be found guilty. So I am saying that I will accept whatever decision you decide to impose upon me as a sentence, but I still maintain my innocence. Now, courts aren't a super big fan of nolo contendere pleas or Alfred pleas, just because it's like, well, are you guilty or not? Like, if you're not guilty, then fight the charges. But I mean, sometimes the evidence is so stacked against you that you're like, well, I'm innocent, but like if I go to trial, I'm going to be found guilty, so I might as well just get this out of the way now. Again, they tend to be like guilty pleas in the sense that they're pretty hard to take back. The reason we have them is largely for civil lawsuits. So think about, we'll use O.J. Simpson. We'll change kind of what happened. So let's say, okay, O.J. Simpson pled not guilty, right? And he had a trial, and he was found, and this was in the murder of Nicole Simpson and her friend. He was found not guilty by a jury. At civil trial, he was found liable for the wrongful death. Right? So the family pursued a civil case and they found liable. Now, being found not guilty generally cannot be brought into evidence. Right? Defense can try and move it in, but prosecution can't do it. If you plead guilty, that can come into evidence in a civil trial. And guess what? If you plead guilty, you're saying, I recognize that you have enough evidence, like, I mean, that it's beyond a reasonable doubt that I committed this crime. On a civil trial, you only have to prove preponderance of the evidence, so 51%, not 95%. So guilty pleas can come in to civil trials. And usually, as soon as the jury hears, oh, this person pled guilty to these charges, that's the end of the story, right? They've made up their mind. Nolo contendere is basically a way for you to plead guilty without anything coming in, without it being a plea coming in into a civil trial. But a civil trial, generally speaking, you can't say that you pled nolo contendere to a charge. Right? So again, this doesn't happen that often, but just know that they exist. So once we have our arraignment, we begin the fun process of what's called discovery. Now, discovery basically in a nutshell is the defense gets to see, depending on the state, depending on the rules of evidence, but the defense gets to see all the evidence and get a list of all the witnesses that the prosecution is going to call. So the defense can ask them questions, take depositions, so the defense can investigate, so there's no surprises, right? So the prosecution basically has to turn over, except at the federal level, we'll talk a little bit about that, but generally speaking, the prosecution should turn over a lot, if not everything, right? Especially if something is called Brady material. Brady material is anything, even if it's the tiniest little thing, anything that's exculpatory of the defendant. Right? So anything that makes it seem like the defendant is not guilty of Brady material. And courts have, or the prosecution is required, even without a motion, to turn it over to the defense. Right? The idea is that way the defense can use it and create reasonable doubt or whatever. So that being said, there is also a process of reciprocal discovery. So sometimes the defendant has to turn over things to the prosecution, but not to the degree the prosecution has to turn over things to the defendant. And we'll talk a little bit about that. So discovery usually begins, again, after the arraignment or the initial hearings with a motion. It's a standard pretrial motion where the defense just motions for discovery and they exchange information. Now, information is provided to the defendant with reciprocal discovery. In exceedingly rare cases, so the defendant doesn't usually have to provide much information to the prosecution, and they certainly don't have to provide anything that's incriminating to themselves to the prosecution, unless they are going to engage in what's called an affirmative defense. So under the rules of evidence and the rules of procedure, if you are going to engage in an affirmative defense, an affirmative defense is basically where you say, yes, court, I committed the crime. I committed the act. However, whatever I did was either justified or excused. Right? So think about something like along the lines of, yes, I killed this person, but I did it in self-defense. If you plead an affirmative defense like that, where you say, yes, I did it, comma, but in those instances, you actually take on a burden yourself. You have to show to the court by not 95%, not beyond a reasonable doubt, but by a ponderance of the evidence, 50.01% or 51%, that your story is true, that you were acting in self-defense. Right? It's a very low bar. But because you have that burden, you have to turn over information regarding your affirmative defense to the prosecution. Now, there's a lot of stuff that you can protect that you don't have to turn over, but there's quite a few things that you have to turn over to the prosecution. This is also true in alibi defenses. Right? So if you say, court, I am going to say I'm not guilty, and I'm going to prove that I'm not guilty because I have an alibi. Well, guess what you have to turn over to the prosecution? Your alibi, right? And the idea is that it's that way they can vet it, right? They can check it out and be like, oh, yeah, he was in Walmart. There's the security camera. And they can dismiss the case, right? So, and then the opposite is also true. They can find holes in the alibi. They're going to use it. This also pertains to an excuse defense to be like insanity, right? Where you say, yes, I committed the crime, and it was wrong. I like self-defense where I committed the crime, but it was right under the circumstances. Excuses are, I committed the crime, it was wrong, comma, but, and usually this is where we're talking pleas of insanity, right? So I should not be held responsible for my actions. I did it, it's wrong, but I cannot be held responsible for my actions. I could not control them. If you're pleading something along those lines, and things like insanity get pled very, very, very rarely, unlike they show on TV, like it's like less than 1% of cases go to trial will have a insanity defense. So that's what affirmative defense is. Now, the Supreme Court has said that there is no general constitutional right to discovery. But if we look at the rules of courts, we look at court decisions, and we look at statutes that legislatures have passed, we get a general framework for criminal discovery. And the framework is designed to protect the defendant as much as possible, but without giving the defendant an unfair advantage. All right, so the prosecution doesn't have to turn over everything. There's stuff that they can keep to themselves as long as it's okay in that jurisdiction by statute or by some kind of court decision. But we don't want to give them an unfair advantage. And so we're protecting their rights, but we don't want to just sink everything that we've done. Right, so imagine if you were a prosecutor and you had to turn over every single piece of evidence, every single interview, every single witness's name, every single witness address, phone number. If you had to turn over every single piece of information you have in your file box. The defense is going to have a heyday with that, right? Especially if you don't know what they're going to plead. If you don't know what they're going to call, but they know everything about you, they have an unfair advantage. So we try to find a good balance between protecting the rights and making sure there's no unfair advantage. Now, as I said before, there is a constitutional right to Brady material. Right, so this is what I was talking about. At the federal level, Federal Rules of Evidence 12 and 16 basically say at a bare minimum, you have the right to Brady material. So anything that is inculpatory or exculpatory, excuse me, of the defendant. And the government, under Rules 12 and 16, under the federal level, must give the defendant certain pieces of evidence, including the defendant's statements. So any statement that the defendant has made, whether it is written or oral, the defendant's prior record, right, so you get to see like their criminal history, and tangible items such as photographs, books, papers, documents, data, you name it. So any kind of piece of real evidence, something that we can touch. So statements, background, real evidence that you can touch, and then of course anything exculpatory. That's the bare minimum. The feds have a very bare minimum system. States usually give you quite a bit more, your defendant, quite a bit more information. You get quite a bit, but you'll get witnesses, you'll get witness addresses, you'll get witness phone numbers. And yes, that could lead to intimidation, but the idea is public defenders or criminal defense attorneys, they have investigators who will go out and question people as to what they saw and all those things. Now, again, feds, they have a bare minimum. What's interesting, in Massachusetts, when we did the initial appearance, before you even filed the pretrial motion, they gave you the criminal background first. And so you have that going in. But again, federal level, that's one of the few things that have to turn over. So states, you have to turn over a lot more than you do under the feds. And then we engage in the most fun part of, and probably one of the most important parts, except for bail, of the trial process, the pretrial process, which is motion practice. So motions are just a written request to a court for something. Now, motions can be submitted by the defense or the government prior to trial or during trial, but for our purposes, since we're in pretrial. And the parties literally can ask for anything. Anything. You can file a motion, and there actually is a case where or a news report, but it didn't end up in a case, but it was a report that I think it was defense counsel at the behest of the defendant. Because if you go to trial, you have water on the both sides, that water glasses, right? So they don't have to go and get drinks, whatever they have there. They filed a motion for fruit punch. As a court, we would like fruit punch on our table instead of water. If I recall correctly, the court was like, no. Just basically told them screw on. But you can ask for anything. Right? So again, motions, you can ask for anything. That being said, motions generally concern witnesses. They generally concern evidence and the rules of the trial. Right, so motions kind of allow us to shape the trial, to determine certain things in advance. Now, there are some very common motions. Motion to suppress, motion to dismiss, and motions for change of venue. These are probably some of the most common motions you're going to find. In most criminal proceedings, you are going to find, if you're a defense attorney, you are going to file a motion to suppress. Right? You're going to try to argue that the evidence the police obtained is somehow illegal. It is almost malpractice. It is borderline malpractice to say that the evidence, to not file a motion to suppress. So motion to suppress, and we'll talk about this, and then we'll stop there. We'll pick back up with motion to dismiss and change of venue next class. But this really derives from what's called the exclusionary rule. Right? The exclusionary rule is probably what most of you are familiar with, which is if police obtain something illegally against the Constitution or against the state or federal statute, that evidence cannot come in at trial. So a motion to suppress is when you say, okay, judge, the police violated either the 4th Amendment, 5th Amendment, 6th Amendment, whatever it is, and we want this piece of evidence not to come in at trial. Usually it's going to be an important piece of evidence, right? It's going to be the knife, it's going to be the gun, it's going to be something really, really important. And then you have a small hearing, which is almost a mini trial in and of itself, and both parties can call witnesses. And then the judge will decide whether that evidence can come in and grant the motion, or deny the motion, or the evidence has to stay out and grant the motion. That being said, when we're talking the motion to suppress, it's usually limited to the prosecution's case in chief, right? So the prosecution can't bring it up, but if you bring it up as the defendant, then the prosecution, you've opened the door, the prosecution can talk about it. They can bring in the evidence. Now, this is really important in cases that are like possession type cases. So imagine that you get busted for possession of crack cocaine. And the only way that the police found that you had crack cocaine was they violated the Constitution. They didn't have warrants, whatever they did. And the judge says, I agree. They violated the Constitution. The cocaine, the crack cocaine is out. You cannot use it at trial. Well, guess what it's really hard to do? It's really hard, near impossible, to prove the crime of possession of crack cocaine if you cannot even reference or allude to crack cocaine. All right, so this can result in dismissals. This can result in a favorable plea bargain. So if you get, the more things you get thrown out, the better your plea bargain is going to be. That being said, next class we will continue here with motion practice. We'll discuss motions to dismiss, motions for change of venue. As always, if you have any questions, comments, or concerns, let me know. I'll be more than happy to answer them. Don't forget to wipe down your areas.